Happy New Year, and Happy New Year to you. My name is Anthony Reeves. I'm an attorney practicing in Social Security Disability. So let's go ahead and get started answering your questions for the new year. Alright, our first question of the new year is, do I have to hire a representative in the state where I live to represent me? One of the things that a lot of people don't know is, just in case you're not aware, is that Social Security is a federal program. Therefore, it doesn't matter whether your representative is in your state or in another state. As long as they are able to practice before the Social Security Administration, you can have someone who is not in your state representing you. Also keep in mind that you can either have an attorney or a non-attorney representatives. Social Security is one of the few systems out there that actually allows non-representatives to practice before the Social Security Administration. The only time having an attorney or having an attorney for your particular state becomes relevant is if you're not successful in getting your benefits after going through the hearing process and even going through the appeals council process. Because once you get denied by the appeals council, the only avenue that you have then is to sue the commissioner in federal court. At that point, you're going to want to have an attorney in your jurisdiction who's admitted to the court in your jurisdiction if your case is one that needs to be moved forward beyond the administrative phase. This is your second question. How long do I have to wait hearing once I've asked for one? The primary question that was posed in the hypothetical to me was someone who actually filed for a request for hearing in April of 2011. Here we are in January 2012 and they still haven't gotten a hearing date. Okay, let's kind of walk this through. First and foremost, when you're asking for a hearing date, the hearing date is set based on the date you ask for a hearing, not the date you file. So let's say in this example, I think he filed in 2010. The request for hearing was filed in 2011. The courts are not paying attention to when you filed your application. The date that's relevant is the date you actually filed your request for hearing. Now, the other part is how long you have to wait. It depends on what jurisdiction you're in. Now, I'll tell you, as a member of the National Organization of Social Security Claimants Representatives, we regularly get updates as to the timelines in terms of what is the average time per office. If I don't miss my guess, I think this information is also available on www.ssa.gov's website. Why is that important for you to know? Well, that gives you an approximation of how long certain offices have in terms of processing their cases. Like, for instance, one office may take less than 365 days. So that means from the day you file your request for hearing, you'll probably get a hearing date less than a year from that date. Some, which they're working on trying to whittle down these times, are up to almost 2 years. So that means from the time you file your request for hearing, it may be 2 years later. What I would tell you is that if you have a representative, ask your representative if they can give you an approximation based on their dealings with a particular office, or you can call the hearing office and ask them. Here's one of the things that I tell people all the time. There's no set timeline for when Social Security has to have your hearing. So if there's something going on whereby they're reallocating, they're getting more cases from other areas, they've expanded their area, they've reduced it, they've gotten more judges have retired, a lot of different varying things come into play, there may not be an accurate indication of what's the exact date you're going to have your hearing. I tell people, rule of thumb, brace yourself for 12 to 16 months. Just brace yourself for that. So this way, when you get ready for the hearing, when it comes around, you're ready for it. Alright, let's go to our third question. And this is an awesome question. Someone asked about what is leaving the country, how does leaving the country affect your eligibility with regards to going during the disability process. Here's what I tell people all the time. The only thing that you have to worry about leaving the country affects really one or two things. If you're trying to apply and whether you've been awarded. Now, follow me when I explain this. There are some instances where if you're in another country, you may not, in certain countries, you may not be able to file from those countries. It gets kind of weird because they may not have places in those locations for you to be able to file. So that's the first part. The back end is that if you get approved and you're getting disability benefits, some countries, the Social Security Administration, or as a result the federal government, will not allow funds to be released into those countries. So those are really the two areas you need to be worried about. If you haven't applied at all, or if you're getting money at the end. In the middle, it doesn't really matter much. So let's kind of give it a good example. Let's say you file for disability in Florida. And then you of course, you've got, maybe you have children who live in Germany or children that live in Turkey, and they're in the military and they want you to come visit them for a few weeks. So they fly you over. And you're thinking, oh my gosh, will it kill my case? No, it won't kill your case. Not while you're over there. Now, I will tell you this. If you leave the country during the process, you might want to let Social Security know. Why? Well, if they need access to medical records or information from you, if they need to send you for a doctor's appointment, if you have a hearing pending and you're coming close to that hearing, it might be stink if they're trying to find you and they can't find you and you're not in the country. So my biggest thing is, while you're going during the disability process, just make sure you let people know that you're going to be gone for a period of time if you're leaving the country, and then let them know when you're back, so if something comes up, they can let you know. But for purposes of eligibility, does that mean, will it kill your case if you leave the country for a while and then come back? No, it should not. Alright, going on to your fourth question. Child support and your retroactive back pay, as well as your monthly benefits. A lot of people, I have to kind of explain to them that if you are found disabled and you owe child support, Social Security Administration typically enables various state agencies, which usually your state Department of Revenues, to garnish any outstanding child support that you owe. So now your question then becomes, well, how much can I expect to be taken? Here's where I tell you to contact, this is where you really need to contact your state Department of Revenue, as well as your state Social Security office. Excuse me, as well as your local Social Security office. First, on the one hand, they're more likely not going to take your whole back pay. So if you owe a lot and you're freaking because they're going to take the whole thing, I've never seen that happen. Are they going to take a percentage? Absolutely. But you want to find out what the relationship is with that particular Department of Revenue to determine how much that's going to be in terms of your back pay. Same thing in terms of your monthly benefits. They're going to take a portion of your benefits out of your check per month. The idea is they're not going to gash the whole thing, because you don't want to be in a situation where they take all your money, because if they take all your money, then you're not able to live because you're not getting anything. But they are going to take a percentage. So I encourage you to contact your state Department of Revenue, or whichever state department that's responsible for covering arrearages, and contact your Social Security office and tell them that you're trying to determine what it is in terms of the percentage of your back pay and monthly payments they'll be taking out to take care of your child support expenses. Do that now ahead of time, so this way, if you're trying to prepare yourself for what you're going to be looking at, you'll know ahead of time. Alright, our last question of the day focuses on consultative psychological evaluations, more important, neurological psychological testing. The person asked me, what did I think about those tests? Here's one of the things that I tell people all the time. Social Security typically sends you for testing for usually one of two reasons. One, to resolve some inconsistencies in the file, or two, if they need more evidence in order to make an informed decision. Like in this instance, the person was asking me about IQ testing. Well, let's kind of give it an example. Let's say that the individual was someone who was held back in a lot of classes, was in special education. It's clear that they have problems with reading, writing, and doing math, and they have a hard time understanding things. Well, that information, along with your school records, may alert Social Security that there may be an indication that there may be some learning disability. Well, if no one has ever tested you to determine whether you actually have a learning disability, well, then what they'll do is they will order you to take a test in order for that test to reveal to them if your scores indicate that you have a learning disability. So I always tell, a lot of times people get offended or upset when they see these tests, whether because they believe, oh, they've got everything they need, why are they asking me to test again? And I tell people, listen, it really is to your benefit for them to send you a test. Some representatives disagree with me with regards to this, but I'm always like, this is my philosophy when it comes to tests for two reasons. One, If you're missing something, it fills in the blank. But if there's a problem, it lets the representatives know, it lets me know ahead of time. So if there's something that can be fixed, we can try to fix it, or at least bring it to your attention so you can address it. So I tell people this: if Social Security is sending you for a consultative evaluation, that does not necessarily mean a bad thing. It may mean they need more information, or that there's some conflict within the medical records. It is a lot of times more to your benefit than you realize. Alright everyone, again, I want to welcome you to a brand new year, 2012. Keep those comments and keep those questions going. For those of you who may not know, if you visit my blog page, I actually have a chat function. So during the week, especially on Sundays, because this is my marketing day, catch me up. I mean, if you see me on there live and you have a question, feel free to come in and ask it. I'll be more than happy to do so. If not, keep those questions and those comments coming, and we will make sure we address them. My name is Anthony Reeves, and today again is another episode of your Q&A, Social Security Disability Today.